My Lord, with regard to, may I make a mention, with regard to part 2, item number 2, the matter may be taken up on Thursday.
Okay, noted. Have you informed the other side? Okay, yes, fine.
I seek your lordship indulgence in mentioning part 2, item number 9, 10, and 11. I have taken the consent of the other party, and if this matter may kindly be also taken up on Thursday.
Okay.
Deeply obliged.
I would like to mention on part 2, item number 3, with the consent of the other parties, if this matter be taken up after 2 weeks.
After 2 weeks?
Yes, my lord.
Why?
Or maybe after 1 week.
Your name is here, Lalrin Sang, is it?
No, my lord.
You're appearing on behalf of Mr.
Eflel Engliana. My senior.
Mention is made on behalf of Mr. F.L. Engliana, learned counsel for the appellant, for adjournment of the matter with the consent from the other side. In view of the above, as prayed for, list after 2 weeks.
Much obliged.
For motion, item number 1.
Your lordship, my senior is on leg if the matter may be taken after the next item.
Okay. Time being matter.
Item number 2.
Lordship, this is a writ petition filed under 226 of the Constitution of India. Lordship, basically this writ petition is to challenge the impugned stay order issued by the Deputy Commissioner on his authority of being district collector. Lordship, the impugned order is at page number 22, Lordship. Lordship, as I have prayed interim prayer, so may I go a little bit in details about this content, Lordship. Page number 22. And Lordship, the type one is page number 23, and the translation is 24. I'm reading Lordship 24.
Yes.
To Mrs. J.H. Nuchungi, I'm the petitioner, J.H. Nuchungi. Stay order number so and so. As per government notification, via notification number so and so, Paizol Lelet area, paddy field, is not included in a residential area of Champai town, since the paddy field was declared to be a special economic zone as Egypt. The same is strictly prohibited outside the government's designated town area and within the designated special economic zone. Construction of residential houses, mounting of earth other than for cultivation, and establishment of godowns and establishment of building for other purpose is prohibited. Further, the provisions of Mizoram revenue laws, Rule 10.6 and 11.1, restricted agricultural LSC, periodic pata and garden pass from use of other purposes, as they are for cultivation of agricultural purposes. As you violated the aforementioned prohibitions, you are directed to immediately stop mounting of earth within Paizao area near Pine Hill Gate, unless prior permission is obtained from competent authority. You are prohibited in state from doing any developmental activities with immediate effect. Lordship, the laws referred herein might be Mizoram Land Revenue Rules, Rule 10 and Rule 11, Lordship. Lordship, this impugned stay order was issued and it's not vacated till date. And for that, Your Lordship, I'd like to take Your Lordship's kind attention at page number 4 of my petition, Your Lordship. I have specifically made out my grounds in page number 4. Starting from para 3, Lordship. May I read, Lordship?
Yes.
That there was basically boundary dispute with petitioner's neighboring land belonging to El Rochung Aralte. As a result, the said El Rochung Aralte did not allow the petitioner to use approach road of the land purportedly be made within his land which affected the petitioner's cultivation as she could not even continue her cultivation. Thereafter, with the help of the Revenue Department, an approach road was carved out for the petitioner. The petitioner continued to develop her land by filling the olden ponds situated within her land by chance for better cultivation of the land. However, haters allege the petitioner that she intended to construct a residential building in such paddy field. It is stated herein that the petitioner never intended to construct a residential building. However, like other farmers, she also intended to construct farmhouse within her land. The respondent number 3, for his authority of being a district magistrate, issued an office order date 11/4/25 detailing the executive magistrate to conduct verification. As per the office order, verification was to conduct on the same day, that is 11/4/2025 itself. And para 4, Lordship, that to the utter shock, the petitioner was given impugned stay order by number so-and-so 15/4/2025 by the respondent number 3, noticing her to stop development of her land with immediate effect. The said impugned stay order was issued by the respondent number 3 on his authority of being a district collector of Champhai district, Mizoram. Number 5, that on perusal of the said state order, it is found that the respondent number 3 relied upon, it must be read as rule. Rule 10, Sub-Rule 6, and Rule 11, Sub-Rule 1 of Mizoram Land Revenue Rules, 2013. However, Rule 10(6) runs as, I'm reading, Lordship, Rule 10, Sub-Rule 6, the holder of periodic pata shall comply with any orders issued by the government of Mizoram or officers so authorized in the interest of public health, public conveniences, safety of general public. The petitioner's land is not a periodic pata, but an agricultural land settlement certificate vide ALSC number 3091 so-and-so of 1991. As is the said rule number 10(6) could in no way come into play. Rule 11, Sub-Rule 1 also runs as, the agricultural land settled shall not be utilized partially or wholly for another purpose than specified. However, there is no utilization of the land other than what have been specified. The petitioner merely did leveling of the land as the olden fish pond was about to fill by chance. In the meantime, even before completion of leveling, impugned stay order by number 15, date 15/4/25 was issued against the petitioner, restricting her from development of the land. However, there is not even prima facie proof of development of the land or construction of the building as against the specified purpose. Hence, the said impugned stay order allegedly issued as per Rule 11, Sub-Rule 1 of Mizoram Land Revenue Rules 2013 could in no way be applicable to the petitioner. Number 6. The impugned stay order date 15/4/25 seriously prejudiced the petitioner as her right to property is grossly violated. For the principle of natural justice is violated as no opportunity of being heard was given to the petitioner. However, spot verification of the land was conducted by Executive Magistrate Champhai District, Mizoram on 11 April 2025. But such verification report was not even given to the petitioner. Without any further proceedings, such impugned stay order number date 15/4/25 was issued as a final order. The stay order also stated that unless permission is obtained from the authority, the petitioner was informed to refrain herself from any development of the land. Lordship, after that, Your Lordship, after waiting some weeks, I have filed an application to the district collector for a special permission, like vacation of the impugned stay order. But Your Lordship, even after lapse of more than a month, there's no positive response, not even a written reply from the especially respondent number 3, Lordship. So this particular petition is filed challenging this state impugned stay order, Lordship, as my right is seriously prejudiced. And Your Lordship, as we have seen here, the Deputy Commissioner as a district collector relied upon 2 rules, Rule 11 and Rule 10 of Mizoram Land Revenue Rules. However, Lordship, the first rule, Rule 10...
Okay, leave the first rule, but the
Lordship.
correct one is mentioned in the second one, so leave it.
Yes.
11 is there, isn't it? So it's okay.
So, Your Lordship, the last page number 29, can you take your page number 29, Lordship? This is the picture which was clipped on my side, Your Lordship. Actually, there was an old fish pond here. I was trying to leveling the fish ponds area, and while doing so, Lordship, there was the stay order alleging me that I was about to construct as against the rules, the permissible one, Your Lordship. So,
Will issue notice. See what I've noticed, they have mentioned a farmhouse, okay?
Lordship. Yes, Your
Now,
Lordship, here in
people are
also.
constructing in the name of a farmhouse, big concrete buildings within these areas also. When you say farmhouse, it should only be a Zoom hut. Okay.
Zoom house.
So I think the reason why this order, like other people also constructing concrete buildings within those areas, saying those are farmhouses. In the olden days, farmhouses are Zoom huts. Make sure
Lots of-
that concrete building is not constructed.
Lordship. Yes,
And
in
then
page number
accused
20
of saying a farmhouse, they build proper pakka houses, which is not allowed.
Lordship, in page number 29, there are some other Zoom had also. Yes, we
Only
can see.
Zoom huts which can be
Yes, like that.
dismantled, not concrete pakka houses which
Yes.
people are building within those areas, isn't it? It's only for agricultural purposes.
Lordship, to be
So-
frankly, I am a resident of Aizawl, so I need to have some kind of this.
A slightly
Farm hut
okay
lordship.
Zoom hut that can
Yes.
be. You don't have to go and spend the night there. You can go and spend the night in this thing, Champai, and then go down to your. Because what is noticed is that proper concrete buildings are coming up within those areas.
Lordship,
I think
lordship.
that's why this order has been passed.
Might be.
If you're only filling up the land and not planning to build any house, or even a too modern farmhouse, it's a different matter.
Lordship. At least
In
opportunity
the
of being
accuse
heard.
of farmhouse, they're building big, nice concrete buildings within those lands. And very soon something will happen and we'll not be able to control.
Lordship. And at
Anyway,
least the
we'll
Lord.
issue notice.
Yes, Lordship.
So, or this matter can be settled if the deputy commissioner looks into your application and you have a talk with the deputy commissioner, convince them that you're not going to build a house, then I don't know why you can't settle the matter instead of having to rush to the court, isn't it?
Yes,
When
the
was
lawsuit-
your this thing made? Your
Page number 25.
this was made on which date?
15.5. Impugn order was in April.
15th May, June.
This matter is a little bit urgent because the time now is cultivation season.
That's what. See, basically, it's because of the fear that you're going to build a house, a farmhouse. That also, it should be just a Zoom hut, isn't it? So if you can communicate with the deputy commissioner concerning this matter can be settled actually between the both of you.
If it's possible, that's the best, Lordship. Yes, their main intention might also be restricting some permanent structures.
Yes, well, so it's a,
But
as you violate the prohibition,
you should have listened my explanation first, Lordship, before issuing this
and
impugn order.
establishment of go downs. So you're not going to build any go down
Not
and
go down,
establish
Lordship.
buildings. So no building.
No building, Lordship.
Oh. So I think this writ petition can be disposed of with an order that they should respond to your representation,
Lordship, within a timeline.
since you have clearly mentioned that you're not going to build any go down or building, isn't it? Establishment of building and go downs.
Lordship.
This is not for the purpose, so to consider your representation and dispose of the matter. But if that is the case, then there's no case actually. And until the representation is considered within maybe 3 weeks or 2
weeks.
weeks. 3 weeks, I
3 weeks,
think.
Lordship. But, Lordship, only one simple prayer. As considering the nature of the impugn stay order, Lordship, construction of such permanent structure is not allowed. And in the meantime, Your Lordship, I may be allowed to do cultivation.
Cultivate,
Yes.
and not to construct any building and to dispose of it. So I'll pass the order
Lordship.
later.
Lordship,
So it will be within 3 weeks
Lordship.
to dispose of your representation, and in the meantime, since assurance has been given that
Lordship.
you're not going to construct, you can allow your cultivation.
Lordship, Lordship.
Yes,
Much obliged.
then Louis will dispose of in the
Yes, Your
motion
Lordship.
stage.
Yes, Your Lordship. I have
You
no
got the,
objection.
this thing, no, you have a fair idea of what the writ petition is about. It's concerning a stay order where the
Yes, Your
deputy commissioner has stayed the petitioner from constructing any go down or any building.
Yes, Your Lordship. Okay.
And then because of the report, they have been prohibited from doing any development activities.
Yes, Your Lordship.
So this is okay, development activities regarding construction of so and so, but then in the meantime, they are allowed to continue their cultivation.
Understood, Your
Okay, for
Lordship.
the agricultural purposes,
Yes, Your
since
Lordship.
it is there. So I'll dispose of and I'll pass the order later.
Yes, Your Lordship.
Much obliged, Lordship.
For motion item number 1.
Yes, time being matter.
My lord, this is a criminal petition seeking for release of a confiscated vehicle of a car, Tata Punch, bearing registration number so and so, to the petitioner. That, my lord, this petition is filed under section 528 of the BNSS, read with section 500 of the BNSS. My lord, if I may read section 500 of the BNSS.
500.
Yes, my lord.
What does it say?
Appeal against orders under section 498 or section 499. Any person aggrieved by an order made by a court or magistrate under section 498 or section 499 may appeal against it to the court to which appeals ordinarily lie from convictions by former court. Number 2, on such appeal, the appellate court may direct the order to be stayed pending disposal of the appeal, or may modify, alter, or annul the order and make any further orders that may be just. Subsection number 3, the powers referred to in subsection 2 may also be exercised by a court of appeal, confirmation or revision while dealing with the case in which the order referred to in subsection 1 was made. So, my lord, if my lord, I may
So
take
what is 489? 498?
498. My lord, 498 is order for disposal of property at conclusion of a trial. Subsection 1. When an investigation, inquiry, or trial in any criminal case is concluded, the court or the magistrate may make such order as it thinks fit for the disposal by destruction, confiscation, or delivery to any person claiming to be entitled to possession thereof, or otherwise of any property or document produced before it or in its custody, or regarding which any offense appears to have been committed, or which has been used for the commission of any offense. Subsection 2. An order may be made under subsection 1 for the delivery of any property to any person claiming to be entitled to the possession thereof, without any condition or on condition that he executes a bond with or without securities, to the satisfaction of the court or the magistrate, engaging to restore such property to the court if the court made if to the court if the order made under subsection 1 is modified or set aside on appeal or revision.
Okay, so what happened? You were also a convict or what in this case?
Yes, my lord, for abetment. We were convicted. My lord, if I may take your lordship to annexure number 4 is the order passed by the learned trial judge.
Yes.
That, my lord, the relevant portion is at page number 19, para 9. No, no.
Okay, abetment. 29-1. You were convicted under 29-1,
Yes, my lord.
so and so.
And my lord, we were sentenced under the sentence order is at page 21, and the relevant portion is at page 22, para number 7. As for Mr. Lalpet Tuanga, who is
5
the
months, is it?
yes, my lord.
So,
In
when was the
committing-
judgment pronounced?
The judgment is pronounced on it's dated 8/5/2025.
Oh, so you already, this thing, you have served your term of
Not
sentence?
yet, my lord.
Not yet?
Not yet. And the sentence order is
Okay, so you're still in this thing, in the jail, is it?
yes, my lord. So, my
Then
lord,
when you are in the central jail,
then my
okay, so it's been confiscated. Okay.
it was confiscated, and my lord, if it may be
Will issue
released,
notice?
yes, my lord, and also the vehicle is on loan, is financed by Tata Finance, which we have
Okay,
annexed.
then what's the reasoning of the trial court?
That, my lord, the contraband drugs was seized from the vehicle.
Okay.
The driver is accused number 1.
So the reasoning of the trial court was that what? The sales letter was false or something?
Yes,
Forged?
apparently, my lord, by
Somewhere
Vanlal
I read.
Nunzira. He claimed to be the owner. However, in all the documents, the registered owner is accused number 2.
Okay, who claimed to be the owner?
Vanlal Nunzira is accused number 1,
Oh.
who is convicted. And
Okay, so Vandal Nunzira said the vehicle belongs to me.
yes, my lord. However, in all the documents, registration certificate and the loan file in everything, it's in the name of accused number 2.
So at that time, it says that no person came to just the AC. It's very hot. Here, I'm reading page 23, para 10 of the judgment.
Yes, my lord.
No person came forward till date to claim the said vehicle.
Yes, my lord.
You did not claim the vehicle before the trial court or what?
Yes, my lord. I was not the counsel for the innocent petitioner in the trial court. He was not properly represented. He was represented by some junior advocates. So they did not make any
So
application.
if you had claimed or made an application at that time, maybe it would not have been confiscated. Isn't
Yes, my lord.
it?
Exactly.
Anyway, you'll issue notice.
Yes, my lord.
Hurt Miss Lalngai Saki, learned counsel for the petitioner who has filed the instant petition under section 258 BNSS within brackets 482 CRPC close bracket read with section 500 BNSS, within brackets 454 CRPC, close bracket, for setting aside a part of the impugned order dated 08/05/2025 and sentence order dated 14/05/2025, passed by the learned judge, Special Court of NDNPS Act, Aizawl, and for the release of the vehicle Tata Punch bearing registration number MZ-01-Z-2859 with its related documents, which was confiscated in connection with the above mentioned case. Full stop. The learned counsel for the petitioner submits that the petitioner is the rightful owner of the said vehicle, which he had taken on loan, and she has also enclosed the documents showing that the vehicle was purchased on loan by the petitioner, which is annexure 4 in the said petition. Full stop. Issue notice to the respondent, Ms. Mary L. Kyangte, accepts notice on behalf of the state respondent. Requisite copies of the petitioner to be of the petition to be duly furnished to the learned government advocate. Full stop. Yes.
Yes, my lord. In the interim, if
The learned counsel for the petition has also prayed that in the interim, the said confiscation order may be stayed, since the petitioner would be suffering irreparable loss if the said vehicle remain confiscated during the consideration of the instant writ petition. Stop. Yes, having heard the nature of the prayer made by the learned counsel for the petitioner, this court find it appropriate to stay the order confiscating the said vehicle, Tata Punch, registration number, till the next date of listing. List after 2 weeks.
Your Worship, rather than staying the confiscation order, Your Worship, if this matter can be taken in a short date.
Okay, list after 1 week.
This is a
Be prepared
criminal
by 1
petition.
week. List after 1 week. Be prepared by then. See. Okay. Yes.
deeply
Whether
obliged.
it's really required, whether he's the owner or not. Okay. List after 1 week.
Deeply obliged.
For admission, item number 3.
Okay, it's not working. Very hot, huh? Then switch on some of the fans at least. Yes. Three.
Your Worship, in this matter, TCR has arrived from the the learned trial court. Paperbook may be prepared, Your Worship.
So,
This is jail.
return of service of notice upon respondent number 2 is still awaited.
Yes, Your
So
Worship,
what
that
happened? Where is she? So who's representing respondent number 2?
as of now, no one, Your Worship, since
so-
not
What steps have you taken to issue notice to respondent number 2?
we have sent the format which we have received from the judicial and from the registrar to the police station in charge. So it's
Which
awaited
place?
exit.
Police station in charge? Which police station?
Your Worship,
Find out it's Vivacon.
yes,
Okay.
yes.
So by the next court date, find out what's happening. isn't it?
Yes, yes. Meanwhile, paper book may be prepared.
Yes.
Yeah.
Paper book is ready. Mrs. Mary L. Kiangte, learned additional PP, is present through VC. Full stop. The learned additional PP submits that she may be given time with regards to the issuance of notice to respondent number 2 by submitting that steps have been taken through the concerned OC. However, no return is received till date. In view of the above, list after 2 weeks. Meanwhile, it is seen that paper book is ready. The copies of the paper book to be duly furnished to the, I think it's been furnished. To the learned PP and the learned amicus curiae. List, I think I said after 2 weeks.
Item number 4.
My lord, White order dated 2306. I was directed to take steps upon the respondent. However, my lord, if I may make one submission that there is a connected IA for condonation of delay. There was a delay of 427 days. And the IA was disposed on 11/6/2025, wherein Mr. Ram Murmu has appeared for the instant respondents. And I have received information from the said council that he will be appearing in the main case.
Okay.
So I have also already served copy of this petition to the council, my lord.
Anyway, he is not present today.
Yes.
Mr. Tila Zekima, learned counsel for the petitioner, is present. The learned counsel submits that the sole respondent, is it,
My lord.
was represented in the connected IA number
32 of 2025.
32 of 2025. Full stop. He submits that he has been informed by the counsel who represented the sole respondent that he will be also appearing in the in the main case,
My lord.
instead of instant, in the main case. Full stop. It is, however, seen that none appeared for the respondent. In view of the above, list after 2 weeks.
Obliged.
For orders, item number 5 and 6.
Your Lordship, in this matter, notice was issued in last court dates. I haven't gone through the application. If I may be given just a bit time so as to see whether objection is required to be filed or not, because we have already filed affidavit in opposition in the writ petition at this stage, making an amendment in
Anyway, what about the corrections made? He has done that. He for the corrections which are required to made. During has been disturbed. Yes. So in the IA,
yes.
okay, whether you want to file any objection.
Yes. I want to see whether it's going to plead to this or not.
I don't think there should be any objection. What is the corrections required? You had mentioned.
My lord,
Does it change the nature? Huh?
yes, it's in para 2 of my application. The impugn order dated 34 of 2002 was mentioned as 34 2022 in several para of my repetitions, and order dated 7/4 of 19.
So in those, the date was
only the year, yeah. This
the
month.
year. It should be 2002, but it was mentioned as 2022.
Yes, my lord.
No objection is required in that. Will allow, isn't it? Simple matter.
I don't know, Your Lordship, because I haven't gone through the application, because
Notice
this
was already
pertains
given to
to
you.
a permit. Yes, Your Lordship, this pertains to a permit that was given to the petitioners. So I don't know whether the date will prejudice me or not. If I may be given the
Typographical
date,
error. This is a typographical error. Okay. So if the year is mentioned wrongly, what will be your problem? I don't think. See here, the impugned order. Now, is there a impugned order of 2022?
No, my lord.
30/04/2020. There's no such impugned order. The impugned order is 2002. So that typographical mistake was made. What objection do you have? You have to, I mean, I think this is
I'm not, I'm just,
okay. And a copy of the writ petition has been given to you. So, they were filed in the writ petition. They had made a mistake. Instead of saying the impugned order dated 30/04/2002, they mentioned 30/04/2022. So we'll allow. But since it's an IA, we had just issued notice, isn't it? Yes. So Miss
Bilaram Nami.
Vilal Ramengi, learned counsel for the applicant, is present, along with Mrs. Mary L. Kiangte, learned government advocate for the state respondents. This is an application for making a correction of the typographical errors found in the connected writ petition number 141/2023. The learned counsel, new paragraph, for the petitioner submits that in the connected writ petition number 141/2023, there was some inadvertent typographical error wherein the impugned order dated 30/04/2002 enclosed as Annexure 16 had been inadvertently mentioned as 30/04/2022. Full stop. She therefore praised that the correction may be made in the following lines. Okay. Then that is, you look at page 4, A, B, C, D, E till F. Okay. Till F, and then order dated she also mentioned that the order dated 07/04/1999 was also inadvertently written as 07/04/19, just 199. Okay, 19 was missing. She further submits that the Annexure 3 of the writ petition, page number 32, is in the Mizo vernacular, and that she may be allowed to enclose the English translated version. Considering the nature of the corrections which are required to be made in the connected writ petition number 141/2023, this court finds that the corrections are purely due to typographical errors, and therefore find it fit to allow the applicant to make the necessary corrections in the connected writ petition number 141/2023. Accordingly, the instant IA number 74/2025 stands allowed and disposed of. The learned counsel to take necessary steps in making the corrections, and the corrected copy is to be duly furnished to the learned counsels for the respondents. Yes.
Obliged.
List after. List the connected writ petition number 141/2023 after 2 weeks. Yes.
Item number 7.
Your Lordship, this case is being handled by Pivani Siami and she's on legs in the other courtroom. So if the matter may be listed after some time, Your Lordship.
This is an application for condonation of delay. How many days? 79 days.
Lordship.
Are you planning to file a written objection?
Your Lordship, that I cannot say anything on this regard because the case has been endorsed to Ms. Vani Siami and I have not been given instructions in that regard, Your Lordship.
We'll give them time to file their written objection, if any, isn't
Yes,
it?
Your Lordship.
Mr. Tilal Nunsiama, learned counsel for the applicant, is present. While mention is made on behalf of Ms. Vani Siami, learned government advocate, who is not for adjournment since she is not able to appear, being on legs in the other court. So, in view of the above, that's the matter after.
OP number 1, ID card is not returned. OP number 1, private party is there.
Okay, who is
No ID card is
notice
returned.
not complete?
Not complete, Lordship.
Okay. It is also seen that notice is not, AD's card is not returned from respondent number 1, is it?
Yes, OP number 1.
Opposite party number 1, sub-respondent, opposite party number 1. In view of the above, list after 2 weeks.
Lordship, may be permitted dusty service, Lordship.
Let's see after 2 weeks.
Lordship.
List after 2 weeks.
Much obliged, Your Lordship.
Item number 8.
May it please Your Lordship, this is an application for condoning the delay of 5,244 days
Many days.
in filing the substitution application.
Substitution application.
Yes, my lord. The reason for the delay is that we were not aware of that the respondent number 5 had expired. And it was only informed to us in the previous court date. So
Okay.
there was a delay.
We'll issue notice first, isn't it? I heard Mr. Zoram Chana, learned counsel for the applicant, who has filed the instant application under Section 5 of the Limitation Act, 1963, seeking the condonation of 5,244 days in filing the connected substitution application that is IA within bracket C number 99/2025 in FAO number 3/2025. Issue notice to the opposite parties. Yes, Mr.
May I please, Your Lordship? I have instruction to appear on behalf of respondent number 5.
Okay. Then Mr. T. Lal Zakima accepts notice on behalf of respondents number 1, comma. Then Mr. 2 and 3.
C. Lal Futlonga, Your Lordship, for
C-
respondent number 4.
Okay, C. Lal Shoitluanga accepts notice on, for respondent number 4 and Mr.
Zaudin Priyanamte for respondent number 2, 2, 3, 5, and 6.
And Lal Namte accepts notice on behalf of respondents number 2, 3,
5 and 6.
5 and 6.
My lord,
Okay, full stop. Then, Ms. Louis, learned additional, learned government advocate, okay, also accepts notice on behalf of the state respondents number 7 and 8. Anyone else? No need to issue formal notice. Yes.
it's only with regard to substitution of the respondent number 5. And since my learned friend had instructions to appear on his behalf, and whether it can be taken up for disposal, because my lord, he is not even a
Are you going
necessary
to file
party.
any written this thing, objection or no?
From our side, no. No objection.
He is the concerned person, my lord.
Uh-huh. Yes, what about the others? Can we dispose of today?
Your Lordship, on behalf of the state respondents, no objection will be filed, Your Lordship.
Yes. No need to issue for Mr. So-and-so learned counsel for respondents 2, 3, 5 and 6 submits that they will not be filing their written objection. The learned government advocate also submits that they have no written objection. They will not be filing their written objection. Then, what about the others?
My lord, I am yet to receive complete instructions from the respondent number 1. So if
learned
time may be
counsel
given.
and Mr. So-and-so. Yes.
Yes,
have
Your
prayed for
Lordship,
time.
we do not have any objection to
Okay.
the application.
Then you'll mention the 3 of them. They have submitted that they will not be filing any written objection instead of separate. Okay. While Mr. Tilal Zekima, learned counsel for respondent number 1, has prayed for time to get instructions.
My lord, the thing is that they are pressing for the execution before the trial court, and they want to delay this matter.
No, we'll list it in next week. Simple matter.
The
List the
concern- the
matter.
concern-
Yes.
yes, yes.
List the matter in the next week. Yes. Give them time next week. We'll dispose it off.
Okay. Obliged, my lord.
Item number 9.
May it please your lordship? This is an application for implement of the new incumbent Shri Khili Ram Meena as respondent number 7, my lord, to the contempt case number
Chief
14. of-
Secretary.
Yes, my lord, Chief Secretary.
Okay, heard Miss Valentina so-and-so, learned counsel for the applicant, who has filed the instant application under Order 1, Rule 10, read with Section 151 CPC for implement of the present new incumbent Shri Khili Ram Meena, Chief Secretary to the Government of Mizoram, Miniko, Khatla, Aizawl, -796001, on the transfer of the previous Chief Secretary who was arrayed as respondent number
1.
1. Issue notice, Ms. Nandui, learned government advocate, accepts notice on behalf of the... No. This is an the contempt.
Yes,
isn't
yes,
it?
my
Yes. On the transfer of who was arrayed as respondent number 1. Okay. In the connected contempt case number 14/2024. Considering the nature of the application, this court find it fit to implead the present incumbent, Mr. Khili Ram Meena, Chief Secretary to the Government of Mizoram, Miniko, Khatla, as respondent number 7 in the connected contempt case number 14/2024. Accordingly, IA number 101/2025 stands allowed and disposed of. Now, in the main contempt case, on the disposal of IS within brackets C 101/2025, notice be issued to the newly impleaded respondent number 7, then Ms. So-and-so, okay, Mr. So-and-so, Chief Secretary, through registered post with AD within 2 days, returnable by 3 weeks. List after 3 weeks.
My lord, if I may also be allowed to change the cause title page.
List after 3 weeks. Meanwhile, the learned counsel for the petitioner is to change the cause title reflecting the name of the newly impleaded respondent number 7.
Much obliged.
My lord, I may kindly make a mention for part 2, item number 5. The respondent, Mr. J. Ishram Nemoya, is out of station, so we won't be able to take up the hearing in this week. So
Item number 5.
Item number 5, Lordship. RFA 27 of 2023.
You are for the
I'm for the appellant lordship.
And
Mr. J. Ishram Nemoya is indisposed for this week, so we won't be able to take up this matter.
Ms. Rosalind Ilmar, learned counsel for the appellant, is present and submits that since the learned counsel for the respondent is said to be indisposed, she prayed that this matter be listed after 1 week.
Obliged,
Accordingly,
lordship.
list after 1 week.
Obliged, lordship.
Thank you.